In the historical streets of London, a famous legal case unfolded, the Carlill versus Carbolic smoke ball. It began when the Carbolic smoke ball company made a bold advertisement, claiming their product could prevent influenza. However, Mrs. Louisa Elizabeth Carlill falls ill after using it. Then she decided to seek justice in a court, setting the stage for a landmark legal battle.
Meet Louisa, a plaintiff of this case walking through a courthouse hall determined to hold the company accountable for their advertised claims.
Outside the courtroom, Louisa is patiently waiting. Louisa's decision to bring the case to court comes from her belief in consumer rights and the need for accountability. Meanwhile, the Carbolic Smokeball Company, once confident in their advertisement, now found themselves on certain ground. They realized their advertisement ideas has landed them into a legal trouble. Jump into the courtroom. As the defendant presented their case, they argued that the advertisement was merely an expression of opinion and not a legally binding offer. They claimed that the terms were too vague to be a valid contract, trying to release themselves of any liability.
In contrast, Louisa argued that the advertisement should be unilateral contract, as a specified condition for offer and acceptance.
She stressed she had already gone through the requirements and the company must keep its promises, citing legal precedent to support her position. Finally, the judge delivered her verdict, stated that Louisa's interpretation of the advertisement as a binding contract. As the judgment was pronounced, Louisa looking so happy as justice is served. The company, on the other hand, faced the consequences of their action. The court held the Carbolic Smokeball Company accountable for its violation of contract and ordered them to pay the promised reward, set an important precedent in consumer protection law.
And that is how the case is ended, leaving legacy on consumer rights and the importance of clear and specific orders.
But before the courtroom drama began, let's talk about the core issue of the case. Whether the contract is a valid contract, whether the defendant's advertisement which appeared in the Pall Mall Gazette was an offer, whether the language in defendant's advertisement regarding the £100 reward was meant to be an express promise, or rather a sales puff which had no meaning whatsoever.
The Carbolic Smokeball Company presented three arguments in defense against Louisa Carlill's claim. Firstly, they argued that their advertisement was just a puffery or marketing hyperbole not meant to be taken literally. They claimed that the language was too vague to create a binding contract. Secondly, they stated that even if the ad could be considered an offer, there was no valid acceptance, a crucial part of a contract formation. Carlill never explicitly communicated her acceptance of the offer, which they said was required for a unilateral contract. Thirdly, the company contended that enforcing such a contract could lead to fraud. They claimed it would be hard to verify if customers had actually used the product as directed, creating the potential for abuse. Carlill, however, had a strong counter-argument. She pointed out that the company's advertisement made a clear promise: use the smoke ball and receive £100 if you still got the flu. The company's deposit of £1,000 in the bank supported this claim, indicating the company's intent to follow through. We agree with the English Courts of Appeals ruling that the advertisement constituted a unilateral contract and Carlill's claim was valid. The advertisement's language could be seen as a genuine offer, and the deposit proved the company's intent. This outcome reinforced that companies must be careful with their advertising language as it can create legal obligations. In summary, we support the Court of Appeal's decision in favor of Carlill. By following the terms of the advertisement, she was entitled to £100 compensation, showing that companies must fulfill their public promises.